A draft of Donald Trump's executive order targeting big tech censorship has been released. It may change, and by the time you're watching this video, he may have already signed it. But I gotta say, I read through this thing, and it looks like Donald Trump has just nuked big tech from orbit. It's smart. I feel like a lot of the points made in the executive order make sense, and this very well may prevent some online censorship. Now, of course, all of the pundits are lighting up across social media with their opinions about what's going to happen. I obviously have mine, and I will say it now. They're all wrong. They're all wrong. I don't think people understand what's really going on with Section 230 for the most part. But I got a Georgetown law professor who gives us his opinion, and it really does look like Trump's executive order is correct. He is not, as they say, going to take away liability protections from social media companies per se. Trump's executive order authorizes the FCC and potentially the FTC to enforce existing law that has long since been ignored. You see, for the longest time, we've dealt with social media censorship, mostly targeting conservatives. Really good examples would be #LearnToCode and rapper Zuby being suspended for saying, "Okay, dude." Section 230 was not intended to protect platforms from removing that kind of content, but they do anyway because no one's been enforcing anything. So I don't want to mess the context up. I want to read you the news that as CNN reports it, show you the executive order, and go over what this means. And dare I say, I think in the next month or two, we may not see any dramatic changes necessarily, but we've already seen Jack Dorsey, the CEO of Twitter, step up, admit to, presumably, I would say it appears like he's admitting to his mistake in fact-checking the president the other day because they put a fact check on Trump's opinion, editorializing content, which is in no way protected by Section 230. The big question arises, are social media platforms publishers or platforms, right? I call them a platform. Now, that argument doesn't necessarily matter. It kind of does in certain areas. It's basically this. CNN is a publisher. They choose what appears on their website. Twitter is a platform. They let anybody sign up and post things within reason. Section 230 has very clear guidelines as to what Twitter is allowed to remove and still remain a platform. But if Twitter is editorializing Donald Trump's tweets, which in no way violate any provisions of Section 2 or in no way fall under the exemptions of Section 230, then Twitter, even though for the most part they are a platform, still cross over into publisher territory. What does that mean? It means you can sue Twitter for the things other people say. Long story short, what we're hoping to get out of this executive order, it may not happen, is that Twitter will be forced to uphold lawful and legal content, and taking down things that violate certain rules, yes, but they can't ban you for saying "learn to code," and they can't ban you for having nasty opinions. But let me give you the full context. First, let's read what let's read what CNN has to say. And I do want to show you some conservatives who are very much opposed to some of these changes, and we'll go through what this means. Before we get started, head over to timcast.com/donate if you'd like to support my work. There are several ways you can give, but the best thing you could possibly do, share this video. Why? Well, YouTube suppresses content like mine. They really do, and they prop up the mainstream media. The mainstream sources like CNN get front page access when dealing with certain issues, like they get a dedicated section. Meanwhile, I get removed from recommendations. One of the reasons, people are really concerned about what Trump is doing with his executive order. I don't think the executive order is going to change this problem I face, which means the only thing I could ask of you is to share the video because it helps keep my channel going. It's the best marketing possible. However, if you just want to watch, make sure you subscribe to the channel, hit the like button, hit the notification bell, and let's get to the news. CNN reports Trump is set to announce an executive order against social media companies. I don't want to read too much of what they say because I actually have the executive order for you, and I'll just give you the legit reporting. But CNN being biased, we've already seen them coming out against this. I'm curious. President Trump is set to announce an executive order against social media companies on Thursday, days after Twitter called two of his tweets potentially misleading. Mind you, those tweets were opinions. Twitter should not have been intervening. The draft executive order being prepared by the Trump administration tests the boundaries of the White House's authority. In a long-shot legal bid, it seeks to curtail the power of large social media platforms by reinterpreting a critical 1996 law that shields websites and tech companies from lawsuits. It marks a dramatic escalation by Trump in his war with tech companies as they struggle with the growing problem of misinformation on social media. The president has regularly accused sites of censoring conservative speech. They do, it's a fact, and we have more than enough evidence. We have seen numerous exposés, leaked emails. It is a fact that they do this. Hashtag learn to code. It was admitted by Twitter's higher ups to me personally on the Joe Rogan podcast that perhaps they were a little too aggressive in policing a hashtag. Learn to code. If you're not familiar, conservatives were essentially mocking journalists who had written stories for years saying that coal miners who lose their jobs should just learn how to program computers to find new jobs. So when journalists started getting laid off, a lot of people said, learn to code. Some people used it in a neutral reference, like actually just referencing the phrase itself. Meaning you could be on Twitter and you could say, I'm confused as to why hashtag learn to code is so offensive. Boom, you get banned. And a lot of people did. That arguably, according to this new executive order, would not be exempt. In this article from Reclaim the Net, they have provided us with the actual draft of President Trump's social media censorship executive order. For those that aren't familiar, Reclaim the Net is a site that deals with issues of censorship. I'm not going to read all of it, but I'll read as much as I can. By the authority vested in me as president, by the Constitution and the laws of the United States of America, including the Federal Property and Administrative Services Act of 1949, as amended, it is hereby ordered as follows. Free speech is the bedrock of American democracy. Our founding fathers protected this sacred right with the First Amendment to the Constitution, underscoring that the freedom to express and debate ideas is the foundation for all of our rights as free people. The emergence and growth of online platforms in recent years raises important questions about applying the ideals of the First Amendment to modern communications technology. Today, many Americans follow the news, stay in touch with friends and family, and share their views on current events through social media and other online platforms. As a result, these platforms function in many ways as a 21st century equivalent of a public square. I'm going to stop right there. That is not Trump's opinion. That comes from a Supreme Court ruling. Let's read. As president, I have made clear my commitment to free and open debate on the internet. Such debate is just as important online as it is in our universities, our businesses, our newspapers, and our homes. It is essential to sustaining our democracy. In a country that has long cherished the freedom of expression, we cannot allow a limited number of online platforms to handpick the speech that Americans may access and convey online. This practice is fundamentally un-American and anti-democratic. When large, powerful social media companies censor opinions with which they disagree, they exercise a dangerous power. Online platforms, however, are engaging in selective censorship that is hurting our national discourse. Tens of thousands of Americans have reported, among other troubling behaviors, online platforms flagging content as inappropriate, even though it does not violate any stated terms of service, making unannounced and unexplained changes to policies that have the effect of disfavoring certain viewpoints, and deleting content and entire accounts with no warning, no rationale, and no recourse. At the same time, the social media platforms are invoking inconsistent, irrational, and groundless justifications to censor or otherwise punish American speech here at home. Several online platforms are profiting from and promoting the aggression and disinformation spread by foreign governments like China. Google, for example, created a search engine for the Chinese Communist Party, which blacklisted searches for human rights, hid data unfavorable to the Chinese Communist Party, and tracked users determined appropriate for surveillance. Google has also established research partnerships in China that provide direct benefits to the Chinese military. For their part, Facebook and Twitter have accepted advertisements paid for by the Chinese government that spread false information about China's mass imprisonment of religious minorities. Twitter has also amplified China's propaganda abroad, including by allowing Chinese government officials to use its platform to undermine pro-democracy protests in Hong Kong. Now, we get to the policy portion where we get a bit more in the weeds, but this is very, very important, and I'll do my best to break this down for you. Section 2, protections against arbitrary restrictions. A, it is the policy of the United States to foster clear, non-discriminatory ground rules promoting free and open debate on the internet. Prominent among those rules is the immunity from liability created by Section 230 of the Communications Decency Act. It is the policy of the United States that the scope of that immunity should be clarified. I'll just give you the quick gist and then we'll read through this. There are specific provisions in Section 230 that guarantee Twitter, Facebook, YouTube won't be sued if I say something that's defamatory or in other ways causes trouble that leads to a legal problem. However, there's clear guidelines as to what they can remove, and they clearly violate it. Let's read. Section 230 was designed to address court decisions from the early days of the internet, holding that an online platform that engaged in any editing or restriction of content posted by others thereby became itself a publisher of the content and could be liable for torts like defamation. As the title of Section 230 makes clear, the provision is intended to provide liability protection to a provider of an interactive computer service, such as an online platform like Twitter, that engages in, quote, good Samaritan blocking of content when the provider deems the content, in terms of subsection 230 C2A, obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. Subsection 230 broadly states that no provider of an interactive computer service shall be treated as a publisher or speaker of content provided by another person. But subsection 230 C2 qualifies that principle when the provider edits the content provided by others. Subparagraph C2 specifically addresses protections from civil liability and clarifies that a provider is protected from liability when it acts in, quote, good faith to restrict access to content that it considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. The provision does not extend to deceptive or pretextual actions restricting online content or actions inconsistent with an online platform service. When an interactive computer service provider removes or restricts access to content and its actions do not meet the criteria of subparagraph C2A, it is engaged in editorial conduct. By making itself an editor of content outside the protections of subparagraph C2A, such a provider forfeits any protection from being deemed a publisher or speaker under subsection 230 C1, which properly applies only to a provider that merely provides a platform for content supplied by others. It is the policy of the United States that all departments and agencies should apply Section 230C according to the interpretation set out in this section. Let me try and break this down and tell you what they'll then be doing. The Wall Street Journal, the New York Times, they choose which content appears on their front page. They have employees, they pay them. There is almost no user-generated content, perhaps maybe other than comments. The New York Times will not be held liable for what someone in a comment section says. That's basically what 230 is trying to do. However, they specifically outline it's in good faith and the content is considered to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. Would anyone consider the rapper Zuby's tweet, okay dude, to fall in line with any of those provisions? Dare I say the answer is no. If you're not familiar, Zuby is a rapper who on Twitter responded to someone in a political debate saying, okay, dude, like just basically ending the conversation like, okay, dude. However, they apparently deemed this to be some kind of hate speech, and so they suspended his account. That seems to be completely editorial, and I do not believe any reasonable person, a court, or could justify how that falls under objectionable behavior. I mean, it's certainly not obscene. It's not lewd, lascivious, filthy. It's not violent. It's not harassing at all. What Trump is basically saying with this is that if these are the terms set forth, then the FCC needs to start enforcing these, and that means people should be able, if we get this clarification, to sue Twitter in the event that they engage in this behavior. Long story short, Twitter will have to make a choice. It'll probably be on a case-by-case basis, but Twitter, YouTube, and Facebook could risk losing their protections if they start editorializing content. Take a look at what Donald Trump tweeted in terms of mail-in voting. The other day, Donald Trump said, there's no way that mail-in voting doesn't lead to widespread voter fraud. An opinion, predicting the future. Of course, there's no way to fact check that. It's a statement about what he thinks will happen in the future. But Twitter decided to add a tag to his tweet, thus editorializing well beyond the scope of what's actually protected. Here's what I want to clarify this for you too, because this is very, very complicated. I am not a lawyer. But if the protection is based on someone posting a comment, right, then you certainly wouldn't argue that a commenter publishes for the New York Times. However, what if the New York Times goes in and starts editing the comments made by people? Well, now you can argue that they're actually working with those comments as part of their general publication. Of course, there's a very, very strong argument. We're going to hear a lot of back and forth. But just because Twitter has hundreds of millions of users they don't regulate doesn't mean they're not a publisher like the New York Times. The argument ultimately becomes murky. It's I got to admit, this stuff can get confusing. Some people on the left have argued it's actually the First Amendment that protects social media platforms from having to allow anyone to speak. They argue it this way. If I have a company and my company, say, puts up a sign in the window and I let some people put up signs in the window, that doesn't mean I have to let everyone put up a sign in the window. However, if your argument is that the enforcement of Section 230 would violate the First Amendment, then dare I say Section 230 has violated the First Amendment from the outset and would need to be revoked. Now, interestingly, Joe Biden himself has called for revoking Section 230 outright. So he's in the context of Section 230, we can see it at the New York Times. He says it should be revoked. It should be revoked because it is not merely an internet company, referring to Facebook. It is propagating falsehoods they know to be false, and we should be setting standards not unlike the Europeans are doing relative to privacy. What we're seeing here is that Democrats want to remove this protection because they do view Facebook, Twitter, YouTube, etc. as publishers of that content. If that's the case, and that's the view of the Democrats, then it doesn't matter if 230 exists. Section 230 isn't supposed to be protecting them at all. There's no reason to revoke 230 if these companies are operating outside the confines of what the protection is supposed to be. Therefore, what Trump is saying should be getting fanfare from everybody. Because think about it. It means that they're not going to be protected from civil liability if they know and help falsehoods. It also means that they'll have to choose to allow people to speak freely, no matter what. Of course, I think the real issue for many Democrats is that fake news, misinformation, or information that generally proves them wrong is out of their control. And they want Facebook to delete things that make them look bad. There's a lot that's going to happen. According to this, they want within 30 days, the NTIA, the National Telecommunications Information Administration, to file a petition for rulemaking with the FCC requesting that the FCC expeditiously propose regulations to clarify the conditions under which an action restricting access to or availability of material is not taken in good faith within the meaning of subparagraph C2A of Section 230, particularly the condition under which such actions will be considered to be deceptive, pretextual, or inconsistent with the provider's terms of service. He also goes on, however, and says there could be issues with deceptive practices and changing of terms of service. I'm not going to read through the entire thing because I can't make an hour-long video, but I'll do my best to give you the gist of it. If a platform like YouTube tells you, here are the rules, you can come and build your business and do your thing, but then arbitrarily in violation of those rules suspends you, shuts you down, or due to public pressure shuts you down, you could argue that's deceptive, because you had essentially a contract with the company they are violating. Now, of course, many of these companies actually say they can ban you for any reason outright. You can try and sue, you'll probably lose. In the end, what I think will happen is there may be clarifications here. This probably won't do a whole lot. People may try to start suing Twitter and Facebook for liability issues. And if their protections are in question, it ultimately could be a very, very bad thing for everyone. I don't think that's going to happen. Twitter, Facebook, YouTube, etc., they're too big to fail. So ultimately what ends up happening is they better stop removing legal speech like #LearnToCode and allow people to say their opinions. Otherwise, well, they'll really lose all of those protections. This is the hope. Let me show you. I believe I tweet from Count Dankula. He said, if they choose to be a platform, that means people like Alex Jones and many other people who have been banned could possibly come back. Opinions and comments that could get you banned, like Learn to Code, wouldn't be bannable offenses anymore. And Dankula is right on that, though I don't necessarily think it will be an issue of one or the other. I think it will be a case-by-case basis. But it involves their liability protection, so it could ultimately just be as Dankula sees it, that as soon as Twitter steps over that line by editorializing the president's tweet, they lose those protections, in which case they just don't do it. Jack made a very, very serious mistake, and I'll show you this. Mark Zuckerberg Knocks Twitter for fact-checking Trump. Says private companies shouldn't be the arbiter of truth. Yeah, well, Facebook runs a fact-checking arm that goes in and smacks labels on things. So they're granting that power and they should not. It's tough, man, because you get a lot of people spreading a lot of nonsense on Facebook. Making money off it, too. Well, Jack Dorsey of Twitter chimed in. He said, there is someone ultimately accountable for our actions as a company, and that's me. Please leave our employees out of this. We'll continue to point out incorrect or disputed information about elections globally, and we will admit to and own many mistakes we make. This does not make us an arbiter of truth. Our intention is to connect the dots of conflicting statements and show the information in dispute so people can judge for themselves. More transparency from us is critical. Yeah. Jack made a glorious mistake. It was one of the most epic failures of policy I have ever seen. And I mean it. At a time when Donald Trump and conservatives are looking for a reasonable approach to dealing with censorship, you edited the content of a non-rule breaking tweet that falls under none of the provisions of Section 230. It was Trump giving his opinion about mail-in voting. Not objectionable, not lewd, not lascivious. Violated none of your rules at all. Trump didn't make a statement of fact. He made an opinion. You can argue you can't mislead people about elections, but Trump was giving his opinion. What happens is Jack Dorsey put a tag on that tweet which linked to the opinions of other people. And there it is. You have just forfeited your entire argument. In Paterson, New Jersey, right now, I live in New Jersey, a leader of the NAACP in the state has called for an election to be outright canceled because of widespread voter fraud allegations and corruption charges. The vote was done by mail-in ballot, and there are a whole lot of inconsistencies. Signatures don't match. People are being disqualified. Packs of votes are just being discovered. And so it's even the NAACP saying we got to do this over. Jack Dorsey saw Trump's opinion and decided to editorialize it by linking to the opinions of other people who don't like him. In no way was that fixing misleading information. Jack and his team think they know better. They think they're smarter. They're not. I'm not saying this as a dig against him. I'm saying it. They literally see Trump's tweet and say, that's incorrect. It's being disputed. Therefore, we should add context. We should editorialize. We should add a sentence to what someone else said on the platform. That immediately crosses them over outside of Section 230 provisions. It was a huge mistake. And of course, it was exactly what Trump needed to say, there it is. They have now added a sentence to my tweet. They have edited my tweet. They have changed the text of what I have published. That is what the New York Times does. That is not what an open platform does. So we'll see what this leads to. But I believe now you could actually argue, with or without the executive order, that based on the actions of Jack Dorsey, they have just forfeited Section 230 protections. They are actually editing the content of the users. They're determining what appears. We'll need lawsuits before things can change. But let's take a look at some comments from some experts, and we'll give you better context. Randy Barnett is a Georgetown law professor who said, whatever legal implications may result, it seems that both Twitter and Facebook are online publishers in competition with other publishers for advertising and eyeballs. The fact they regulate their content only further underscores this. They are not an ISP like Comcast or RCN. If they're not publishers with First Amendment rights, then perhaps they are closer to common carriers who have a duty not to discriminate. Georgetown law professor. He brings up a really great point. Facebook, Twitter, and YouTube, yes, YouTube, are in competition to sell advertisements. Well, that's what newspapers do. They're actually regulating the content that appears on their platform. Simply because they don't have strong editorial guidelines doesn't mean there aren't editorial guidelines. There are. YouTube passed rules on what we were allowed to say about the pandemic. They gave us editorial guidelines. They actually sell ads and split the money with us. YouTube is playing a very, very dangerous game. My livelihood is YouTube. I've been very successful and I'm very fortunate, but I'll be the first to admit YouTube is very likely to be a publisher the same as any other service simply because they allow me to be on their platform. Let me tell you something. They review channels to determine whether or not you get access to cash, in which case there's a strong argument that they're just a company hiring people. I would not be happy with it. I'll tell you what. It would be very, very bad for me and my livelihood, but the argument stands. They're competing with the New York Times. They have a large group of people who produce content. The company then sells ads against it. I don't sell any ads. I just get paid based on the ads that come in. It's going to be a really wild ride moving forward, and a lot of people aren't going to like it. I know I probably wouldn't. It could be the end of my YouTube channel. We'll see how this plays out. Ben Shapiro chimed in, saying, here's the inevitable effect of destroying 230 of the CDA. All comment sections will be taken down. No website has the resources to actively edit all comments in order to shield themselves from liability, and no website is willing to leave comments entirely standards free. The invitation to redefine unfair business practice to include comment policing-based lawsuits will likely not end well for conservatives. I see the appeal, but I'm wondering just why conservatives are suddenly so unconcerned about political bias among regulators. But I will add, I don't think it matters removal of Section 230, Trump's executive order. I think the fact is there hasn't been a strong legal case brought to a judge to point out the fact. Twitter says publish on our platform, and we are just a platform, right? But Twitter sells advertisements on this platform. Now, the difference between, YouTube and Twitter is that Twitter doesn't pay you, but they do monetize the content you're producing, which would be no different to say, I don't know, the Huffington Post or Forbes, who are publishers and are liable. Long story short, when the Washington Post says something, they're the ones who said it. If they defame you, they can be sued. Twitter makes money off of our content. They choose who gets to appear and who gets to publish content. They will remove you for saying things like, okay, dude. Clearly, they have editorial guidelines. Therefore, what's the difference between Twitter and the Huffington Post? And I mean that literally. I understand you can point out solid differences like, well, the Huffington Post, they write articles and Twitter is a microblogging site. I don't care. The Huffington Post allows users to post, and so does BuzzFeed. What's the difference? You could argue that the Huffington Post has the same protections for sure, but they do edit the content. Okay, Twitter has now stepped into that game and directly edited Donald Trump's tweet. Well, there you go. They're now 1 degree into that same territory. I also have this tweet from Robbie Sucrose. He says the obvious consequence of removing liability protection would be social media companies censoring more speech, not less. This order is about assuaging Trump's bruised ego, not protecting free speech. In fact, if your goal was to force Twitter to take more aggressive action against Trump and against edgy right-wing speech, what you would do is suspend the liability protection. Say goodbye to tweets implicitly accusing Joe Scarborough of murder. In fact, this is part of the reason that many progressives of the Elizabeth Warren variety are adamantly in favor of removing the liability protection, as well as Joe Biden. Here's what I think we need. I think we need these companies to stop banning legal speech. That should be the standard. Many people are speaking out against, these changes and this enforcement. I don't agree with that necessarily. The executive order may work. It may actually tell Twitter, don't ban, lawful speech and set your rules to be as such. That would mean that someone could be on Twitter and say really, really awful things, like really nasty racist things, and they couldn't get rid of it. Same for YouTube. It would mean that they can't ban my videos when I say a name. It's lawful speech. It's protected. It would incentivize them to be hands off, but it would not mean they would ban more. It means they would ban less. That way they don't get sued. The biggest problem right now is that Section 230 has not been clarified. Trump is seeking to do that and enforce the law under this. I have no idea how that will play out. We can only see. But let me just wrap it up with this. In the end, probably nothing will happen. I mean it. I really, really do. I mean, nothing will happen. It would be devastating for, I think nothing will happen. I really don't. I just don't see it. The courts have struck down so many lawsuits. An executive order, while it's clever, won't necessarily do anything. But it will be interesting to see how the FCC seeks to regulate certain content. But this really is about liability protection. So even if the FCC determines that, I'll put it this way. It may be that starting, in 1 month, the FCC says, here are the clear definitions of lascivious, of objectionable. Okay, dude, clearly is not in there. Twitter then says, okay, from now on, we won't ban legal speech. That would be the best outcome. We'll see how it plays out. A little longer for you today, but stick around. I've got more videos coming up at 6 p.m. at youtube.com/TimCastNews, and I'll see you all then.